All right, good afternoon, everyone. Welcome to another Q&A session. It's Friday afternoon, at least here in Ottawa. It's beautiful weather today, or at least getting to be warmer weather after a few days of what looked like it was going back to winter with some cold weather and some snow. So I hope everyone out there is enjoying. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin. As mentioned, I'm here in Ottawa. I work in Ottawa, but I also assist clients throughout all of Ontario. And so I'm here today, once again, to answer all of your questions. I'll be here for the next half hour or so. So send in your questions, any questions that you might have related to your work, your employment, workplace issues, health, safety, COVID-19, layoffs, anything at all. Send them in and I'm happy to answer them. I see that we have a few questions coming in already, and I'll get to those in just a moment. So as I was saying before, any questions at all that you have, anything you've been wondering about that you're concerned about, definitely send those in and we'll do our best to answer those questions for you in the next half hour or so. So I do, as always, have a list of things I did want to talk about, but I do much prefer to answer your questions. So I will get to the questions, and then if we have time to talk about some of the employment issues that I was going to talk about today, some of the issues that have come up, especially in the news this past week, we will get into that, some of which is related to paid sick leave, which I'm sure lots of people are happy to hear about. The provincial government in Ontario, at least, announced that they're going to be looking at that. So we can talk about that as well. But I will get to the questions now, and then we'll see if we have time for some additional discussion afterwards. So I'll start with a question from Todd. Todd says, I've been dealing with harassment at the workplace. I was forced to resign by my employer after complaining about this. Is there anything I can do about that? Well, absolutely, Todd. If you are like Todd and yourself, Todd, any situation where you are dealing with harassment in the workplace, if the workplace has become unsafe for you, if there is bullying or harassment, that goes to the safety of the workplace. And employers have an obligation to provide and maintain a safe workplace. So if that's not the case, then the first step that you would take if you feel like you are in an unsafe workplace and you are not being treated the way that you should, the first step is you bring it to the employer's attention. It sounds like that's exactly what Todd has done here. The first step is you file an internal complaint. Every company, every employer will have a specific process of how you do that, and that process should be available to you as an employee. So you should know exactly, if you're dealing with this type of issue, who do you go to, who deals with this type of issue, where do you go to complain, how do you send your complaint in? All of these questions should be answered by your employer's policy. If you're unaware of a policy that exists, if one hasn't been provided to you, or you can't access it, then you should be going to HR and asking if they can provide you with that. Now, once you've made that complaint, then the employer does have an obligation to investigate it. They can't simply choose to ignore it. They have a legal obligation. So the law requires that they investigate it and that they investigate it properly. If they don't investigate it properly, then, or they don't investigate it at all, I should say as well, then the next step would be to go to the Ministry of Labor. And you can file a complaint with the Ministry of Labor, in essence, to complain that your employer has not investigated your workplace health and safety complaint. The Ministry of Labor will then appoint an investigator who will look into it and will either force the employer to investigate, carry out their own investigation, and in certain cases, they might even fine the employer for not doing what they were supposed to do. So in terms of Todd's question, so to answer basically your two questions here, you can't be forced to resign for having made a harassment complaint. So I would need a bit more information about the actual circumstances of what happened, because I'm not sure how, Todd, they would have forced you to resign. Is it that they wouldn't address your complaint, the workplace was so toxic that you had no choice but to resign? If that was to happen, then that would be illegal, and the employers failed in their obligation to maintain a safe workplace. But on top of that, you may even have a constructive dismissal complaint, which is something that happens where if the workplace is so toxic that you cannot work there anymore, then it's a constructive dismissal, meaning it's not an outright termination of your employment, but it's a situation where the employer has made it such that you actually can't continue working because of the unsafe work conditions. So in a situation like that, if it's a constructive dismissal, then you would be able to go after your termination entitlements and your severance pay. In terms of the situation after having resigned, if you did resign recently, it's very important, Todd, that you act quickly and get legal advice. You can contact us directly by going to employmentlawyer.ca or emailing help@employmentlawyer.ca so that you can get some advice, because if you did resign, you need to act quickly in order to make sure that you preserve any legal claim that you might have. If you resign and then you don't do anything about it for many weeks and many months, you might actually lose the right to pursue any legal claim. So it's really important that, Todd and anybody who's in this kind of situation, first of all, you should get legal advice before you take action and before you resign. But if you can't or you don't, and now you've resigned, then at least get the legal advice now so that you can pursue any legal recourse that is available to you. Now I see that we have some questions coming in. I'm just going to try and scroll down to some of the other questions. So here's a question from Mad, who asks, if an employee working in a restaurant is laid off due to a government-enforced lockdown, can the employer claim force majeure as grounds not to pay severance? So that's a very good question, and it's one that we get a lot these days because of the pandemic, and especially because there's been an additional lockdown and stay-at-home order recently in Ontario. So it's very important to understand that if you are put on a layoff, and the employer had a choice to lay you off, meaning you've never been laid off before, you haven't agreed to a layoff previously in writing, in an employment contract or any other document, then the employer actually doesn't have the right to lay you off. We don't have to accept it. You can treat it as a termination, and you can go after severance pay. Now, that's in a situation where the employer has a choice. In the situation that Matt is describing here as a restaurant worker, unfortunately, with the government forcing restaurants to shut down, at least in terms of having customers attend at the restaurant, they're allowed to do takeout, but that's it. If you are, let's say, a server, then unfortunately the employer didn't have a choice. They had to lay you off because the government is forcing them to do that. So if you're in a situation where the government has forced a shutdown or has forced the employer to not be able to continue your employment, even if it's just on a temporary basis, then unfortunately that is a situation where it wouldn't necessarily be force majeure, but there would be an explanation or at least a justification for the employer to implement that type of situation. If, however, to use the same example, you work at a restaurant and you're a server, and the government is allowing restaurants to be open, with restrictions, of course, then that would not be the same justification there that would exist, because they're not being forced by the government to not employ you or to not provide you with hours or work. So if it's a forced situation by the government where the employer has no choice in the matter, then that isn't a situation where you would be able to pursue severance pay and claim constructive dismissal. However, if the employer has the choice and it's not a situation that has been implemented by the government, then certainly that same principle would apply with respect to illegal layoffs and potentially going after severance pay. So we'll just get to another question here from Kabir. Kabir is asking, can employers be taken to court over favoritism and not being fair to one employee? So it's a bit difficult, Kabir, for me to answer this question without more information about what exactly the favoritism is, who's being favored over whom, and what is the kind of unfair or fair treatment being talked about. What I can say in general is that favoritism in and of itself is not unlawful. It's not prohibited by the law, as long as it's not discriminatory. So if an employer just happens to like one employee more than the other, that's okay. But it cannot come out in a discriminatory manner. So if, for example, that employee is being treated better because they are younger, or on the flip side, I'll reverse that. If between two employees, one is 65 and one is 30, and the 65-year-old has been told that they should retire and they're not being given hours, and they're not being treated the same as, let's say, the 30-year-old employee, then that's an instance of, I'll loosely use your term could be your favoritism, but really it's discrimination, because that 65-year-old employee would be receiving lesser than treatment and negative treatment, potentially just because they're 65 years old. And the reason we know that is because of the comments made about retirement. It might be that, age happens to be a coincidence here, but if there are actual comments made about it, then that would be an example in terms of, what discriminatory conduct might exist. So it all comes down to the Human Rights Code and the grounds that are protected under the Human Rights Code. Some of those grounds are age, disability, ethnicity, creed, gender identity, sexual orientation. So if there is negative treatment in the workplace for one specific employee, and it's likely because of one of those types of grounds, then that's not lawful, and certainly you would have legal recourse at a human rights tribunal or potentially in court, depending on the situation. So if you are in a situation like that, or you know somebody who is Kabir, you certainly should get legal advice, because every case is different and every case is analyzed on its own facts. So that's kind of just to give you a bit of general information about what you've asked. I hope that helps. But certainly you should be getting legal advice if you're concerned about something of this nature. So I see there's a few more questions coming in that I'm going to get to. So Ali asks, or says, my employer owed me 8 hours of overtime back in late 2019. They said my contract does not allow any overtime. I called the MOL, the Ministry of Labor, and they said we can send a notice to the employer. My employer refused again. Okay, so a couple of things here, Ali. If your employer does owe you overtime pay, absolutely the best way to address it is through the Ministry of Labor. I wouldn't recommend going through the Ministry of Labor for things like severance pay, because most of the time they can only get you a very small amount, whereas through a lawyer we can get you your full entitlements of common law when you're let go. So that's something that isn't necessarily something you'd want to go to the Ministry of Labor for. But situations where it's overtime pay or outstanding wages are perfect examples of items that the Ministry of Labor can assist with, and they can assist you for free. So you certainly were right to go to the Ministry of Labor over that. If there's overtime owed, then I'm not sure from your question, Ali, if you actually filed a complaint or just mentioned it to them on the phone. Because once you file a formal complaint through the Ministry of Labor, they actually will investigate that. They'll get information from you, they'll get information from your employer, and then they'll make a decision as to whether that overtime pay is owed. And if they do choose, or at least determine that you are owed the overtime pay, they will order the employer to pay that to you. And then if the employer doesn't comply with that order, the Ministry of Labor will go after them and force them to do it. So certainly that's what you should be doing. It doesn't sound like you might have filed a complaint. It sounds like you may have had a conversation with them about it. But certainly you should move ahead with filing that complaint and having the Ministry of Labor determine if the overtime pay is owed. The other thing that is worth mentioning, because your employer, Ali, is saying you're not owed overtime pay will depend on your position. So if you are in a managerial role where at least 50% of your duties are managerial in nature, then you aren't actually entitled to overtime pay. If you're not in a managerial role, then you are entitled to overtime pay. So that's something that you certainly should be pursuing. Just get to the next question here. Well, I see it's a question from Rupert. Actually, Rupert, I believe that you had emailed me the other day, and I responded to your email asking you to provide the information with respect to your employer. So I recommend that you respond to my email and just provide me with the information that that I had requested from you, and then I'll be able to further assist you on your question and on your concern, because there was a bit of information that was missing. And I'd be happy to correspond with you offline on that. So just check your emails. You'll see I sent you an email, and just respond to that with the information requested, and we'll go from there. So we'll move on to the next question here. So it looks like I have a question from Paul, and there's a few messages sent in with questions. I'm able to see some of the actual scenario here. So it looks like, Paul, there's an issue here with respect to both yourself and your girlfriend working for the same company, and an issue with respect to them asking her if she was pregnant. I'm not able, unfortunately, to see the whole fact pattern here, and there seems to be a bunch of information missing. But what I will say is that in terms of your girlfriend's situation, an employer does not have the right to inquire with respect to whether someone is pregnant or not. That's private information, and if you happen to be pregnant and you happen to be planning for a maternity leave, then of course you want to give your employer some advance notice of that type of leave if it's required. But you don't have to provide them with that information, certainly not in the earlier months, and certainly not until a couple of months or so before there needs to be a planned leave, in order to give them time to plan for that leave. So there might be some discriminatory conduct here, given that anything related to pregnancy is actually protected by the Ontario Human Rights Code and by each province's Human Rights Code. So not just in Ontario, any province that you find yourself in, that type of issue, pregnancy, family status, gender, those are all grounds that are protected by the human rights legislation. So an employer does not have the right to be asking these questions, and they certainly don't have the right to be treating an employee any differently if they do happen to be pregnant. So I hope that gives you a bit of helpful information, Paul. It looks like, based on the information you've provided here, that this is a very complicated situation. So feel free to contact us offline so that we can get into the details of this situation, because it does seem quite complicated based on the limited information that we have here. And again, you can contact us by going to our website, employmentlawyer.ca. Every single lawyer's contact information is on our website, employmentlawyer.ca, and you can contact any lawyer, including myself, through that website. And you can also email us at help@employmentlawyer.ca. So I encourage you to do that, because it seems like, again, your matter is quite complicated, and we want to make sure that we're able to give you comprehensive advice on this. We'll just move to the next question now. So Edward from Facebook says, I got suspended for work refusal after an accident report filled out. Suspension document has 3 names with no last names. My union was a part of my suspension with a completely false document and said nothing, knowing I'm on modified doctor's orders. So Edward, the first thing that I have to tell you is that, unfortunately, because you're unionized, you have to go through your union on this issue. You cannot have an employment lawyer assist you with it because you're unionized. And it does sound like your union has been involved in the process. You might not be happy, unfortunately, with the representation that you're getting from your union, but they are involved, which is their obligation. And you have to go through them. You're unable to actually hire a lawyer to deal with this privately, or sue the employer for any of this situation. Now, in terms of a suspension, usually your collective agreement would govern that. So in your collective agreement, there should be a section about suspensions and the type of behavior that could result in a suspension, and how the suspension should take place, and the situations surrounding it. So you really need to go to your union on this issue. I can't speak to the fact that they've suspended you and whether that was lawful or not, because I haven't seen your collective agreement. So you do need to go through your union there. But if it was an unlawful suspension, if you refused work because you required accommodations because of a medical issue, then that certainly doesn't sound like a lawful suspension. But if that's the case, then your union would have to represent you in a grievance against your employer. So definitely contact your union rep and push and press the issue with them in order to address this. I'm just going to get to the next question here. So Northern Mustangs from YouTube says, hi, I signed my employment agreement with using the words under my signature duress with this. Oh, and I just lost that question. I'm just going to try to get it back. There we go. With this on my employment agreement, will it have any benefit if disputing something in the future? That's a great question. So it depends on the situation. You simply writing duress on the agreement doesn't mean that the agreement itself is unenforceable. It's an indication that there might be a condition where there was duress in terms of you signing it, but duress is actually analyzed by looking at the context, by looking at the circumstances surrounding when you signed it. So in other words, just because you feel like you might have been forced to sign an employment agreement, in the eyes of the law, that doesn't mean that you actually were forced. So there are certain circumstances where sometimes duress can be found if an employer truly did force you to sign it. But most of the time what happens, at least in my experience from what I see, is people feel like they're being forced, and understandably so. Most of the time an employer will put a contract in front of you and say, this is the contract you have to sign, otherwise we're going to fire you. And most people do not want to lose their jobs, so they'll sign the contract. But what most people don't know is that that isn't actually being forced. That's the employer trying to pressure you into signing a contract, and you don't have to sign that. So these are the types of circumstances that a court would look at in order to determine whether the contract is enforceable that you signed. But I will say just the fact itself that you signed it is not great. It likely would be enforceable based on that, unless there were other kind of extenuating circumstances. The other thing I'll mention as well is, in terms of the contract itself, if you're concerned about a specific portion of it being enforceable, so for example, if you're worried about a termination clause, if you didn't have a limit to your termination entitlements, and now that you signed the contract, you do have a limit, or at least the contract looks like it might limit your termination entitlements, it doesn't mean that it actually does. And that's because employers have to use very specific language in order to limit your termination entitlements and your severance pay in your contract. So if that's something that you are concerned about, or if any other of the provisions are really what you're concerned about rather than the whole contract, I would recommend that you get in touch with us, and we can certainly review that contract for you and let you know what's what. We can also let you know if there might have been duress based on the circumstances in which you signed it. But if it is that termination clause, most of the time, those termination clauses are not enforceable, because usually companies do not use the very specific language that has to be used to try and limit your entitlements. So if, let's say, you don't get it reviewed by an employment lawyer, you just kind of let it be for the time being. If ever you are let go, certainly have that reviewed by an employment lawyer at that time, because that's when you really need to know what your termination entitlements are and whether that contract does limit you or not. I'm going to get to another question. John from YouTube asks, if you open up a side part-time business, can that void your severance eligibility? So the quick answer to that is no. In general, there wouldn't be any situation where if you have a full-time job and you have a second part-time job, if you get let go or terminated from your first full-time job, you would still be owed severance pay. The fact that you have another job does not impact on that whatsoever. The only thing that I would be mindful of is sometimes you have a term of your employment or condition of your employment that says you can't have a side job and you can only work exclusively for that one employer. That's something that I sometimes see in employment contracts that some of my clients are asked to sign. So if you have signed a contract that says you have to work exclusively for this one employer and you can't work for any other employers. And if specifically it also says you can't work for a competitor at the same time, and then you do go out and get a second job, let's say working for a competitor, that's a situation where you're purposely breaching a term and condition of your employment, and that could potentially lead to a termination for cause of your employment, meaning that a termination for cause exists when you engage in very serious misconduct that's intentional, and that would be a situation where you're not owed severance pay. So it's a bit of a theoretical situation, but I wanted to mention it because it did actually come up a couple months ago. I had someone contact me who was in this exact situation where they did sign a contract that said they couldn't work for another company and they couldn't work for a competitor. They went off and did that, and then they were terminated for cause. So that would be a very specific set of circumstances where you might not be eligible to receive severance pay. But in general, having a second job does not disentitle you to severance pay if you are let go from your first job. I'm going to get to another question here. I'm just scrolling through. Just looking for, and I apologize, I'm having issues scrolling through. There's so many questions that have come in that we're having a hard time scrolling through and seeing all of them. So I want to make sure that we get to as many as we can today. We have a few minutes left during this question and answer session. So I'm going to try and get to as many as I can. So I have one from Vern on Facebook, who says, I was heard at work 5 years ago, going to a WCAT tribunal / hearing. I assume you mean Workers' Compensation Appeals Tribunal. In August, they have now also said I declare myself Indigenous as well and have me a navigator. I have workers' advisors assistants. I'm a pile driver / iron worker, and the employer said, and this is where it cuts off, unfortunately. But it looks like, Vern, that you're dealing with a workers' compensation issue. I'm not sure which province you're in, but either way, you're dealing with a workers' compensation issue. You certainly can contact us offline in order to deal with this, because it does seem like a complicated situation. And in terms of workers' compensation, we do have a few lawyers at our firm, including myself, who do specialize in workers' compensation in addition to employment law, because they're not always the same. They are different areas of the law. And so if you're having issues with that, certainly you can contact us. And if we're not able to actually assist you with that issue, I'd be happy to refer you to somebody who can. But it's just not clear based on some of the information here exactly what the situation is. So get in touch with us. Again, the website is employmentlawyer.ca, or you can email us at help@employmentlawyer.ca. And like I said, Vern, we're happy to help you, and to the extent that I can assist you, I'm happy to. Otherwise, if we're not able to, we will refer you to a workers' compensation specialist that might be able to assist you with the issue that you're having. So I'm just seeing if we have time for one more question. Some of these questions or kind of scenarios that have been sent in are quite lengthy and are quite complicated. And so if I haven't gotten to your situation or your question, please get in touch with us offline. Again, I'll give you the website. It's employmentlawyer.ca. You can contact us that way. You can email me directly. You can email any of our lawyers directly in order to get assistance with your issue. Because unfortunately we're out of time, and I do not have time to get into the specific details that might be required to give you comprehensive advice on your scenario. So I see a few people, Amanda from Facebook for one, definitely get in touch with us and we'll be happy to help you. We just didn't have time to get to that today, but definitely contact us and we'll be able to assist you that way. So that brings us to the end of our time for today. Again, any questions at all, just email or call us if we didn't get to them today, and we'll be happy to help you. Otherwise, there are various question and answer sessions set up for next week and every week, so you can always save your question and ask it at that time as well to myself or one of my colleagues. So we'll leave it at that for today. I hope everyone has a wonderful weekend, and I will see you in the next question and answer session. Bye-bye.